Can we move on to the George Floyd thing? Because I don't know the
Yes.
answer. I don't know how it came out.
Oh,
I don't know how
you
it
are
came
on
out with the
pins and
George
needles,
Floyd
aren't
thing.
you?
I do. I do not know how the federal case came out. I have missed this memo. I have a sneaking suspicion I'm going to disagree with the verdict. But
So this is the
I
federal
don't know
case,
how
right?
it came, yeah.
Yes,
I don't
the
know
federal
how
case.
it came
They
out.
just came out
Apparently-
with a verdict today.
Apparently
Yeah,
it came
I
out this
saw the
morning.
verdict,
I don't know what the answer is yet. It's a whole spoiler for me.
B movie review. Thank you so much for your super chat. So yes. So for anybody that hasn't been tracking, obviously Derek Chauvin was convicted in Minnesota on state charges last April for the death of George Floyd. It was the whole knee on the neck thing. The whole thing that sparked the BLM protests in 2020, the thing.
Thing, like Joe Biden. Yes,
exactly.
Yeah.
So anyway, the other 3 officers that responded to the scene, they are still facing state charges, but they have been most recently in trial on the federal charges, which obviously are not televised because of the fact that it is in federal court. Much to everyone's dismay.
And we won't get those transcripts probably for a couple months, which is annoying.
Yeah, it'll probably be a long time. And even then, it's like when you read a transcript, it's different than actually seeing it.
It's not
because the same. Someone's body, there's so much that gets lost in people's body language, their the way, their tone, the way that they shift in their chair when they talk, it's so much gets lost in
the federal courts need to get over themselves with the whole. Now, I'm not so sure about the Supreme Court level, but at least for the trial level, even for the court's appeal level, I think they need to get over themselves with the video thing. Not so sure about the Supreme Court level, because at least in the Supreme Court, we have because we have equivalents, right? We have contemporaneous audio or nearly contemporaneous audio. So we don't quite run into the same problems. I'm not sure we necessarily need video. I take contemporaneous audio. I mean, it's not as good as video, but it's better than a transcript, which I'm not going to get for 3 months.
It's also
the Ninth Circuit.
Go ahead with the Ninth Circuit. Go ahead.
No, I'm just saying the Ninth Circuit's starting to do it, roll it out.
Yeah.
So hopefully
the Court of Appeals for DC Circuit is doing it.
The difference between the Supreme Court and District Court is that the Supreme Court has only one time in its history ever taken actual testimony. If it's not testimony, it's just legal debate. So tone and people pausing before answering a question versus jumping right out and answering a question.
I have to give Joe a point here. I have to give Joe a point that I'm slightly impressed that about that one thing with the Supreme Court, the actual testimony. So point to you, sir, for knowing that little piece of history.
It is actually
for me.
It's actually a case I was thinking, like, you know what? I'm going to actually tell that story and basically spend an hour and a half going through that whole complex story as to how the Supreme Court once took testimony. This is going back like literally a century ago.
Yes, like mid-18th, or is it early? Was it like 1820?
No, I don't think it was that long ago. It was. I think it was after the Civil War, and I think it involved. Yeah. But it involved. It's a story involving a black man who ended up being lynched after a marshal just disregarded a Supreme Court order. So they ended up taking direct testimony themselves. So, but. That we'll save that story for another time. I'll probably cover that on my channel sometime when I'm bored. But because it's a really cool thing, the Supreme Court. But my point is that there's a very big difference between testimony, where someone's relaying the facts, being questioned about facts and how they respond to that, than 2 attorneys who are arguing about a position. Yeah, because you don't care about their you don't
really care about their body language.
Yeah, you don't care about their body language. It's not a question of do I believe his story or what she's trying to convey here, or do I think she's lying? That's where you really care about that, and that's where that's why district court level, it's really essential that we get that, so we can see, was this guy seem genuine to me or not? You get to feel what the jury was feeling. That's a really important thing. And the fact that that's not public, especially on a trial like these trials that really matter to a large swaths of the country, it's very frustrating.
That's a good point, sir.
Yeah, absolutely. Yeah. So in this case, you had the 3 guys, I think 2 of which were rookies, actually, leading up to this. I mean,
the two guys that were touching George Floyd were the rookies. The third guy, who was a little bit more experienced, was the one with the crowd control.
Yeah.
And so,
what do you mean by touching?
Wrong?
Yeah. The person who was doing crowd control was only on the job for 2 weeks.
Okay, then I flipped it. I'm sorry.
Yeah. And the two guys who were holding the legs, one of the guy was training the other guy. And then Chauvin was training the guy who was doing crowd control.
Yeah. So for my money, and I know I'm just going to be disappointed because I kind of know what the answer is already.
I will not change my face in reaction.
Yeah. For my money. Okay. So under federal law, let's just deal with the federal law elements, right? So we need to show a purposeful deprivation of civil rights. We need to show that these people purposefully deprived Floyd of his civil rights through the use of excessive force. And unless I'm mistaken in the relevant statute, and you can correct me on this immediately if I'm wrong, but doesn't it require also a discrimination element that is being done on the basis of some sort of protected class, like race? Is that also an element of the crime, or am I conflating two things?
Say one more time.
That the actual crime under federal law, to be guilty, not only do you have to deprive someone of civil rights, but it has to be because of a protected reason, such as race. Is a racial reason an element of the federal crime?
I don't think it's always. I don't think it has to be race.
Okay, well, I don't necessarily race, but it had to be some sort of protected reason, right? Like alienage or something like that. My question is
not necessarily, because you can also deprive someone's civil rights if it's like a police brutality kind of case too.
For just straight federal law reasons?
I think so.
Okay, fine. Let's go with that premise. Okay, so
because you could talk about like federal prison, for example. Like I've seen like one of the few qualified immunity cases that where they weren't given qualified immunity was where the prison guards were like literally tying up guys to like a hitching post and like leaving them outside for days.
No, I mean,
it was an Eighth Amendment issue.
I mean, you're right. I will just simply note that qualified immunity obviously in those cases is a civil issue, and we're suing under 1983. So 1983, 42 USC 1983, of course, like every statute, has its own terms. Sure. So that you're right. Under 1983, it's just a straight deprivation of civil rights.
Right.
But under the relevant criminal law, which is like 18 USC 242 or something like that, 243, something like that. Okay, I wasn't quite sure. Anyways, moving past that issue, either way, I didn't really quite see the case for any of them for having the intent to use the excessive force and deprivation of rights. The one officer who's monitoring the crowd, obviously his knowledge is monitoring the crowd. He probably has little to no knowledge of what's going on with Chauvin and Floyd because he's too busy monitoring the crowd. I mean, the crowd is yelling things at him, but he isn't observing that. So I think his knowledge is kind of out the window. For the two people who are on him, one is obviously like first week on the job. It's like, really, this guy is gonna, just shove his other officer off the guy, just shove him off or something. And the other officers are saying things like, I can't feel a pulse. Maybe we should turn him over. Maybe we should get in this other position. So they're feeding him information and be like to their superior. And so the question to me, at least, is I think you can get past all that if you can get to the point where you can conclude that the nature of the violation is so obvious or so pertinent that I was following orders basically doesn't fly. Like, come on, if it was so blatant, that this officer was just blatantly, massively abusing him. But I don't know that it was blatantly obvious because, at least for my money, I'm not 100% convinced at the start with Floyd and Chauvin that it was a violation of civil rights. At the start, it was a violation. I'm not even sure at 1 minute in it was a violation. I'm convinced by the end it became a violation. Mm-hmm. For Chauvin, where exactly that moment occurred, I couldn't quite tell you, nor do I need to, because I know it happened some point prior to the end. But then going to the other officers and their vantage point is like, is it quite obvious with this kind of slow boil? So for my money, I don't really see criminal liability for the other officers under federal or civil law. And this is the part where you tell me that all three officers were convicted of all the charges and found guilty, because I'm sure that's what happened.
Well, just a correction. I messed up, not you, Kurt. You were actually correct initially. I was wrong. It's actually the crowd control guy was 9 years. I don't know why I fucked it up, but I did.
Yeah,
so that, you're actually right. So I was wrong.
So that also, that massively changes the analysis.
I just thought about him like, oh shoot, I corrected the guy in the wrong way. So
it makes them all way more innocent.
Yeah, it also makes them way more innocent. Like the only other guy who would be in a position from his years of experience to be in a position to know anything, because I mean, Nate, tell me if I'm wrong, but isn't like a major theme of brand new rookies when they first come onto the job, a lot of jack shit?
Yeah,
isn't that kind of like just the
FNG,
which is also true. Absolutely zero things.
Well, we call them FNGs
about the real world. Also, kind of true of lawyers for that matter. When they come fresh into practice, is like a lot about theory, but not necessarily about the actual day-to-day practice. It's like jack shit. So these people who are brand new, 1 week out of probation or something, they're gonna be in a position to forcibly stop or massively question the 20-year veteran. I don't think so. Too, yeah. And then the 9-year veteran is the one doing the crowd control, so he's not in a position to observe any of these things. And he's not. I mean, what are we? He's in a conspiracy. He's an accessory. I mean, again, to be in a conspiracy requires agreement and overt action. To be an accessory requires that you have the intent to facilitate a crime, which means that a crime is occurring. If I hold the door open for the bank robber without knowing he's a bank robber, I'm not guilty of accessory. If the bank robber's tire gets a flat and I help him fix his flat, but I don't know he's a bank robber, I'm not an accessory. It requires knowledge on my part the intent to facilitate. So how is all that safe? So I am not convinced based on the evidence that's available. And maybe it's different if you hear the testimony, because none of us have heard the testimony, which is really annoying, because maybe with testimony and picture, it would change the analysis. So, but based on what I know, I'm like, I don't see it. But this again is the part where you tell me all three were convicted and are going to jail.
Well, don't tell them yet. Don't tell them.
I'm not going to tell. Yeah, I'm not going to tell you what the verdict was just yet.
I want to use my black privilege for a second. Now, why am I going to use my black privilege? The Chauvin case was not about race. Did I just say that?
I think it sounded like you said that.
I just said that. So I don't think that case would have been different if Floyd was black or white, right? I think if Floyd was white, the events would have played out the same if all the actors acted the same way. So I don't really think it was about race. And that's why even in the case, they didn't charge Floyd with they didn't charge Chauvin with any race, anything like that. So I think the federal charges about race were also nonsense. I think, unfortunately, what this case came down to was a veteran officer who, unfortunately, for him and for this victim, went too far. When you're sitting on top of somebody for the first, and I think no one will disagree, the first 3 or 4 minutes of that encounter, everything was kind of by the book. It's when the guy goes lifeless and you're still on the body for like another 5 minutes, where you're now in the reckless disregard.
I'll give you 1 to 2. I'll give you 1 to 2.
Even 1 to 2. Yes, one. I'll give you 1 to 2. But then when you're at minute 7, and then for the 2 other cops who were sitting on top of him, who one had 2 weeks experience, the other one was on for a month.
Yeah,
both of those cops asked Chauvin. Were making inquiries onto the safety of Mr. Floyd. One cop said, "Should we move him over?" Chauvin said, "No."
We put him on his side.
Yes. The other cop said, "It doesn't look like he's breathing. He's okay." So these rookies were concerned. They were asking.
They affirmatively made those statements to Chauvin, who was their superior officer, right? With a lot of experience, 19 years in the force. So this is somebody who is like, oh, okay, like if there's anyone to listen to, it's this person. And then he said, no, this is what we're doing.
Maybe we can pull the actual indictments against them, and we can see whether or not race was an element of the charge that had to be proven. Because if race is an element of the charge to be proven, then I'm going to even double down on my consternation.
This would be nonsense.
How do you convince a jury? Assuming that this is a required element, how do you get to the jury to the place of they did all that because of race when there is no facts because I mean, we did listen to the entire Floyd Chauvin trial, and I mean, obviously it's slightly different factual pictures for all three, and we have to do the analysis differently for all three because they're in slightly different vantage points, and even what they heard and saw is slightly different. But we didn't hear anything that would allow us to make the conclusion that those people would be in a position to what? No, did we? Joe's shaking his finger. Joe's shaking his finger at me.
Technically, you're correct that during the civil trial there was no discussion about race. And
criminal trial, you mean?
During the state trial. During the state criminal trial, there was no discussion about race. However, prior to this trial being conducted, by my recollection, Chauvin pleaded to the federal charges.
Yes.
Correct. Yes.
Yes.
And by pleading to the federal charges, it's possible that his plea was something that became admissible into their trial as far as his admission that I haven't looked at his plea in a while. I looked at it quickly, but technically, I don't think any of us have been following this trial at all.
No, because it's impossible.
Right. But if it was admitted,
I think Chauvin
on the record, they would be like, well, and here as a matter of the record, Chauvin has admitted that race was a factor for
which
him.
I believe was true for his charge, if memory serves correctly. That's one of the reasons I was asking the question.
Right. So now once we're saying that race was a factor for him, if they impute that over to these other guys, which I think is possible that could have happened, even though it feels so terribly wrong to me. And such a miscarriage of justice. So I'm not trying to justify a conviction at all. I think the conviction here is purely a mob coming after them, punishing them because it's George Floyd. Not even because it's a black man, but because it's George Floyd.
I don't think that imputation. I mean, I would imagine under the rules, unless Chauvin himself testified at the trial. Did he testify?
I think he made a statement, and his
you can't.
No, that's not gonna work. No, you can't do that.
Cross-examine.
No, because you'd be able to cross-examine. Because even assuming arguendo that he had a racial biased reason for doing those things, it does not necessarily, of course, apply to anyone else because each person's mental state is in a different position.
I don't think looking as a lawyer. You're looking as a lawyer.
I am looking at it as a lawyer. That's what I do with my time.
I understand.
That's who I am. What are you talking about?
But part of a role of a lawyer is to put yourself into where the jury's going to be, and
where the jury's idiots.
Okay, fine, but you have to recognize that as part of the whole calculus as to how things are going to end up coming out. And what I'm saying is, for them to, if they were able to see something, I don't know if they could, but if it was admitted as a matter of record. Here was his statement. If somehow that got in, which I don't think it should have, because I think it's prejudicial, I think it's inflammatory, and it's
against the Constitution.
And I think there's so many problems with it.
Violates the Constitution.
Would it be shocking if it got in? Would you be shocked if someone?
Yes,
a little bit. Yes,
I would be 100% shocked if they allowed a violation of Sixth Amendment rights in a criminal trial, his right to confront his accuser. Yes, if that statement would come in, I would be 100% totally shocked. Because he's available to testify.
Let
me shocked.
That's not Sixth Amendment.
Let me add something for clarity.
That's not Sixth Amendment. That's, if anything, it's hearsay. But
let me add something for clarity.
The right to confront your witnesses. Right. That's cross-examination.
Yeah.
Right.
But so let me add something for a little bit of I don't know, maybe just a different detail or context. So, for example, when you have a witness who is unavailable during trial, either because they live on the other side of the world or because they've died before trial happens, or, for some reason they're not able to come to trial, but they've done a deposition, you read their deposition into
rules.
Of course, but you can read the deposition into the transcript into trial. But generally speaking, the other side then is able to also use different parts of the transcript to basically do their side of the cross examination for it. So even if you have some kind of a statement by any kind of a witness that comes into trial, the other side has to have some ability to respond, because otherwise it's just
a confrontation clause issue.
That's just not fair.
It's textbook confrontation clause.
Right.
It's textbook confrontation clause.
I'm trying to figure out.
I would be shocked.
I'm trying. Look, I'll tell you this much. Assuming there was no testimony, assuming this is an element, which I believe we all are under the impression that it must be an element, or if
it can't be because there's no evidence of it.
Well, that's a question.
I would be shocked. I don't believe there could be any. If they convicted him under this, it's a miscarriage of justice because there's no evidence of it. But I'm not sure. I'm not sure.
Do you want me, or can you pull up the original indictment against the three?
Pull up
do you want me to find? Do you want
what were they convicted of?
The grand jury's indictment.
That's what I'm saying. Is I almost
positive
there was race.
If you can pull it up.
I'll put it in the private chat. I'll find it.
Okay.
Hold on. But then, if I start Googling, I might be spoiled as to the answer. They were all found not guilty, right?
Do you want the answer before you look up the?
Sure. Disappoint me.